Senator Wiggins, Representative Cockerham. How are y'all doing? Y'all ready to get started?
Yes.
Okay,
Sure.
go ahead and call the meeting to
It's
order.
LSU Ole Miss, weekend. So
I got to get you out to the Grove. I'm going to go ahead and call the meeting to order. I had emailed to hopefully everybody on the committee a proposed agenda and also the draft minutes so expertly drafted by Judge McCarty from our last meeting on October 1, 2021. I think the first order we need to do is see if we have a motion on the floor to accept those minutes.
I so make the motion.
Mr. Blackledge, thank you very much. Any seconds? All right, the second from Justice Griffiths. Any discussion? Now that we've had a motion and a second, are there any proposed corrections to those minutes? Hearing none, all in favor of accepting those minutes, say aye.
aye.
Any opposed? Good deal. All right, so I also sent out the proposed language for the no-fault divorce issue, you may recall, and as is provided for in those minutes. Professor Bell, Judge Schlogel, and myself were going to see if we couldn't hammer out the language to be used for the recommendation so that we can put that issue aside and concentrate on the other issues raised by Senate Bill 2621. Judge McCarty called me up and was just raving about the beauty of the language. And I had to tell him, Judge, that's all 100% Professor Bell. It was concise. It laid out very clearly, I think, in bullet point fashion, the reasons why the task force believes that this is the direction to move into. Does anybody have any discussion about that language? That was emailed out a couple of days ago as well. I will entertain a motion for us to adopt that as the language for the recommendation, knowing that we may have to tweak something here and there, but as far as, okay, we have a motion from Judge McCarty. Any second?
I'll second.
Thank you, Reggie, Mr. Blackledge. All in favor of accepting that language in substantially the same form that it's in right now so that we can move on and concentrate on other matters? I'll say aye.
Aye.
All right. Any opposed?
Mr. Chairman, not to drag us out, I just want to say I think that's very well done. And thank y'all for the work that y'all put in, because it's an issue that's been before this legislature for quite a while. So thank you very much.
I don't know how much more clearly or concisely it can be made, and we're limited in the power that we have. But as far as making a recommendation, I thought Professor Bell did an excellent job.
Just for clarification, the recommendation is a separate ground. So we would end up adding a 13th ground? 14th ground. Okay. And so it would be in addition to the irreconcilable differences ground. Okay.
Yes.
Thank you.
And Judge Odom, I'd just like to say as well, I'm very pleased with the recommendation also. So thank you for the drafters for the recommendation. And I know that we've talked, particularly I have, about helping those individuals who may be victims of domestic abuse. And so I see on page 3 of the recommendation, you list some of the reasons or some of the barriers that we've had previously. So I think that this will greatly enhance that. So I just want to say thank you.
Oh, thank you, Representative Cockerham. And I think I also left on there some of the language that I started drafting as far as the issue of tabling child support, requesting that this matter be, this task force be continued for another year to tackle more comprehensively the issue of child support, and there are probably going to be some other issues that we would like to further discuss as well. So just go ahead and start looking at that language. And I imagine that drafting the ultimate recommendation is going to be quite a task. So I kind of want to get some of it out of the way now. Just take a look at that and we can discuss that language later. Okay. I don't know if I asked if there were any nays on that. Are there any nays on accepting that? Then the ayes have it. Okay. Okay. The next matter on the agenda that I have is an issue that was raised by Professor Bell during one of, if I'm not mistaken, the breaks that we had at our first meeting. It's one that I have heard Professor Bell discuss at her annual CLEs before, and it's always one that, a light bulb goes off. Yeah, absolutely. Why haven't we addressed this before? Because as a practicing chancellor, and I'm sure those that are here on the task force that practice regularly in Chancery Court know that sometimes the non-divisibility of PERS can be a challenging aspect of equitable division of marital property. So I asked if Professor Bell would just briefly discuss what the issue is, because I think that it should be an issue that easily we could say yay or nay on, and do some good if we vote for it. Professor Bell, do you mind briefly discussing that, the divisibility of PERS issue?
Is divisible. It is viewed, divided, enforced. It is principle as determined that was the extent that a couple is married and first is required marriage. It's a marital asset and it gets divided. That's true in every state that and in most states, as I see now, in all the states, that can be right. Regular right. So, President Mike for 30 years, all of the purpose was too late during the marriage. And the wife is a state court can order some portion of that directly to the husband. And so she would get based on her court reasoning. In Mississippi, 1977 case, the Supreme Court held that you can't do that. That you can't do this. All of these states have anti-Semitism, but it's not interpreted. Divorce judges aren't interpreted as a so when the court divides it, there are three things that work. They can put a value on it. Or we have a value that's investigation. is, let's say the pension is valued at $300,000. Give the pension to the is to order. Once they start. write a check, at least one. But then it has X.
Of course. Yeah, is that better? Um, Okay. And it's also that payment is just not clear that it's what it is. And so what most states do is allow the equivalent of their PERS system to just divide it. Now, that's not always done. The chancellor has the option of saying, you take the PERS, you take this asset. They have the option of doing a lump sum, but it would add to the options that the chancellor has, and often it would be the cleanest and most efficient way to do it. So that's what I've seen is just the chancellor struggling to find a way to divide PERS without being able to do it through the state like most states do.
Can I ask you a question?
Sure.
The way I understand it is it would be done based on what we know as a qualified domestic relations order. And so PERS would not be the decision-making entity in this. The court would simply issue a form type approved qualifying domestic relations order to PERS, and PERS would simply make a ministerial act of creating or dividing one account into two accounts, following the same rules and regulations of PERS as to the distribution. It would simply split it.
Right. Right. It's a lot of states call it something other than a quadro, but it's essentially an administrative order from the court to PERS saying divide this so that the PERS beneficiary receives 67% and the ex-spouse receives maybe 33%, 67, 33. Yeah.
In doing it that way, if there's a non-employee, non-government employee spouse, and are you saying that you do that and basically the employed spouse and the non-employed spouse would each have an account at PERS? Is it right now? Because I think this is the case that if it's a non-government employed spouse, that they take that money or given that money and go put it in some other retirement plan.
Senator, isn't it, for example, if I retire and then I pass away, my wife would step into my shoes.
Right.
Through my employment. And so there is some basis to, for ex-spouses to continue as a member of PERS.
No. And that's what I'm
You're
getting
asking
at.
about a rollover, I think. So there are in PERS you can cash out and that could be rolled over. But no, if it's the monthly payment that comes from PERS, that would continue to come from PERS. It would not be rolled over into some other entity. So the non-employee would be getting a monthly check from PERS. And I think
That's
this-
how it is currently. Like, I guess what I'm asking is if it's a non-government employed spouse, does PERS continue to give them that spouse the money?
yes, PERS
Okay.
would continue to be the administrator. And
Okay.
one of the things I was going to suggest is I don't know what this would take from PERS end to implement this. But I mean, there's certainly examples. So, I don't know whether it's appropriate to talk with PERS or ask about that. But I looked, and until 2011, it looked like there were 6 states left that took the same position as Mississippi. And since then, Alabama and Tennessee, which were 2 of the states, have changed their rule. So there've got to be recent examples of how you go about converting this. So now it looks like there's Mississippi, Georgia, and I think Indiana are the only remaining states that won't allow their state employment agency to divide these pensions.
And is your research consistent with mine that the only reason I can find for the way that we are now is that Supreme Court decision?
The 1977 decision. And I think it was meant to protect state employees. But the problem is after that, we now have equitable distribution, and they're being divided anyway. They're just being divided in other ways. Yes.
And the provision against garnishing it or attaching a lien to it could still be in effect, even with the divisibility
Right.
of
Right.
it.
This wouldn't do away with the anti-assignment
Right.
clause. It would say that divorce is not a violation of the anti-assignment clause, or it would accept divorce from the anti-assignment clause.
Has this been an issue that's been discussed in the legislature?
Not on the House side, to my knowledge, it has not. No.
Because I would imagine anytime PERS is mentioned, the antenna would go up for any legislator. I don't want to push anything through unnecessarily, but it just makes sense to treat it like any other 401k or other type of retirement that would be divisible then and there, rather than the chancery judge have to make a lump sum come from some other asset that.
So I'm with Angela. No, it's not discussed, but to your point, whenever PERS is mentioned, it becomes, antennas go up. And so PERS is a political issue. And to your point, and I'm thinking as a practitioner here, one of the most complicated or certainly issues is dealing with PERS in a divorce.
It is.
In fact, I had a case last week and every issue was decided except that. And it almost got to the point where it was just going to end up in a trial because that wasn't. And the average legislator doesn't understand. Not that they would need to understand that. I think lawyer legislators who deal in this understand it. And I think the efficiencies that could come out of whatever reform would be great from a practical side. So it definitely is a politics thing. It definitely is something that would have to be, that taken into consideration. But the politics of it, and I'm speaking for myself, come in reducing people's entitlements to that. But if you're just talking about a splitting of it and nobody's losing any money, I think it's more palpable, if that makes sense.
If you're talking about reducing definitely the entitlement of it,
Right.
it becomes a very hot buttoned issue, definitely. And I would just say if there was any even consideration of having a recommendation on this, to Bryce's question about non-state employees, I think he does raise a good point in that we probably would want to get some kind of communication from PERS with respect to how this would be implemented, because I definitely wouldn't want to get any heartburn from PERS on this. And they're looking at Chairman Wiggins and I with the side eye for the rest of the term. But I do think if you're reducing the entitlement of it, it would become very political.
Yeah, that's what we need to be careful here. We're not talking about reducing the entitlement of it. We're actually trying to protect those state employees that may not have a pot of money or equity in their home that they can offset their retirement. But the fact is, the PERS would be marital property, and we're going to have to figure out how to factor that into dividing it. And it would just almost protect the state employees if we could, in those rare instances, make it divisible rather than leave them with nothing other than their retirement.
I'm speaking for myself. And I think the Senate, I certainly would think this should be looked at as it's been presented here for the reasons we've talked about. And the politics side of it, that's for Angela and me too. If the task force says this is something that needs to be done, it'll make it more efficient. This is the right, and we're not going to lose, nobody's losing when we're not reducing benefits, then I think that's really up to us. It falls in that's our job to handle that. And I think a lot of it becomes extra, just like you explained. Once we can do that, then I think it ends up being there.
Chairman, I would suggest that that's something we want to consider, that we reach out to PERS and we have a conversation with them beforehand that is not a political, other than simply, this is a problem we have and we're considering this, these are our reasons, and we would like PERS input on this, because, you know, certainly anytime you raise PERS and people start thinking about their 13th check, and you get a lot of calls. And this is something that's an administrative matter with PERS that I think their input needs to be sought.
Exactly. And that's why I said a few minutes ago, if a recommendation is going to be made, that I think PERS definitely needs to be consulted so that they're in sync with what we're recommending, and we're not recommending something that's not going to be doable for them.
And you know, I would think that, I mean, they've got to be aware that we're one of the few states that don't do that. And there may be some issues with doing it that they're aware of from other states that we need to know about.
Who would be the contact at PERS in y'all's?
The director's office, we can get that information.
We can get that information, and we can, Chairman Wiggins and I, we can coordinate and talk to them and get their input based on what recommendation that the task force has. Chairman Wiggins and I will be in contact with them.
You think it'd be possible to have maybe the director, if they're not busy, join us for the next task force meeting?
Yeah, that leads to another, this would, and I think Angela agrees with this. Because the session's coming up and potential for a special session, I think finalizing some recommendations is where we need to end up, so that we
Yes.
can take that and do what we need to do, because this is actually the time of year when bills are starting to come in, we're starting to make that stuff, so that we can take these recommendations. And I think we both want to make this a priority this session. So my point is, I think they would. I think that that maybe could be done through a letter or a phone call on that, rather than because that may, I guess what I'm saying is that may lead to a need for another meeting or something. And I think we're getting to the crunch time.
And I do agree. I think that the letter or phone call would help in this instance so that we can get the recommendations completed.
Is that Chris? Who is the executive director of PERS? Is that Chris Howard? Or he's just the chair of the board of trustees?
It's me right now. Let's see.
Randy McCoy is the board chair.
And for me to try to write this down, Judge, is what we're going to propose, I suspect something along the lines of we table it for this meeting pending communication with the director of PERS.
With that communication coming from the legislators.
Totally fine by me.
Good. I'm glad that we raised the issue. And I'm glad that Senator Wiggins recognizes some of the issues involved in it.
Oh, gosh, I'm just telling you that, like I said, that becomes practically speaking a big deal, and everybody just shrinks when you're having it in the quadro, and it's just like, and you know what? It literally adds, when I have a client, I advise them, it's going to be an additional 3 to 6 months before we can get this done because of that.
Good. Glad the issue's raised. Is that something we need to like vote on in order to table, or can we just move on, you think? Secretary McCarty?
I think we could, I think it's cleaner to go ahead and make a motion to do it. But the motion, as I recorded it, Judge, motion to table the Division of State Retirement Benefits proposal pending a communication with the Director of PERS regarding a position from that agency.
Very good. Any second?
Second.
All right, so we have a second from, I think it was Professor Bell.
Yes.
Yes. All in favor, or is there any further discussion? Mr. Blackledge, I want to make sure you weren't about to say something. So uncharacteristic.
I wasn't about to say anything.
Very good. All right, all in favor, say aye.
Aye.
Any opposed? Excellent. Okay. One of the issues we raised at our last meeting was the research provided through the Mississippi Judicial College concerning the age of emancipation. By way of review, 47 states, their age of majority is 18. 2 states, the age of majority is 19. And then there's Mississippi with 21. And Puerto Rico. What we did last meeting, if I'm not mistaken, was kind of table it so that people would have more opportunity to review that research and information provided by the MJC, so that we could hopefully formulate a recommendation on it at this meeting. DHS, Mr. McCauley, I believe it was you that raised the issue of, y'all have always at DHS favored 19 to protect those that 18-year-olds that may still be in high school at the time. We have a large number of those. Now that y'all have had additional time to review that research and think more on the issue, is there any discussion about that? We were leaning toward making a recommendation of amending the age of emancipation to 19. Representative Cockerham and Senator Wiggins, what's the position of the Judd committees? Is that something that y'all would like to change?
Well, meaning the Senate, passed it last year.
Yeah.
And I think at the last meeting, Angela mentioned that there's many in the House that want to see it done too. And I think there were just some little issues that had cropped up, and I'll let her speak to that. But so I think the general will is that, yes, to do something. It's figuring out those exceptions that have been mentioned in here.
Yeah, and Judge Odom, I've received a lot of, when I say a lot, whether on Judd or just even from colleagues who aren't on Judd who would like to see this done. So as I alluded to on our October 1st meeting, we did change it with respect to some financial instruments. We changed it from 21 to 18. And so I think there is some support in the House to see it done.
I place a call to Senator Dennis DeBar, who drafted the legislation in the Senate that was emailed over, to find out from him why. What is I'm trying to figure out a good
Did you hear
reason.
back from him?
I did. I talked to him. I did. And his response was, I've got a military background. You be able to serve in the military at age 18. You ought to be able to be an adult at age 18. That was the
It-
reason.
And that position significantly carried the day on the Senate floor when the bill passed. I mean, from a political argument, there's a lot in that.
And that was one of the reasons that I heard in the House as well.
Okay. DeBar mentioned, hopefully I'm not saying anything I shouldn't, that 19 would fall into his realm of consideration. If that would so please the legislators or the task force, he would not be opposed to that. Any discussion? I mean, the biggest thing I can imagine that this would affect would be, as far as the domestic relations task force is concerned, cutting off child support at age either 18 or 19, whatever the law would be if we lower the age of emancipation.
Judge, if I may, and I'm going to lay some cards on the table here, I think the will of the legislature is to do this. I think, though, when it's come up, we hear from chancellors, specific ones who say we don't want it done.
Right?
And I think, because I've heard from one myself, a former chancellor who said that, and I think out of deference to that, that's why we've had an issue going forward. And so, you know, I mean, I'm not really sure if this is what's being done. I'm not really sure where their opposition is coming from. And I think I'm speaking for myself, that has become the biggest opposition to getting this passed in the legislature.
Professor Bell, are you going to say
I
something?
may be wrong, but I'm guessing that might be about college support. Is that, and my comment was going to be, do we need, if this is going to be done, to carve out an exception and to say that chancellors still have the authority to order college support?
Is it
But
that, or they just don't want to give up 2 years of having jurisdiction over the child?
I'm not sure. That was just my guess.
I don't care. I mean, the less children I have jurisdiction over, the better, as far as I'm concerned.
Judge, we do have our conference next week. I mean, is it worth bringing it up in conference with the chancery judges next week at the Hilton?
Oh, yeah. I think you're going to find about a 50-50 split.
Okay.
There are going to be some chancellors that are like, yes, that's fewer issues we have to deal with as far as payment of child support. That's 2 less years or 3 less years we have to worry about. But you're going to have other chancellors that say, listen, I've seen 18 and 19 and 20-year-olds that are completely dependent upon mom and dad, and mom or the custodial parent could really use that child support in order to help put a roof over your head.
And I think, to go back to my point, I think certainly in the Senate, judging by the passage of the bill, the overwhelming sentiment is to do this. But I think what you just said, if it's a 50-50 split within the chancellors, there's been some pausing to get it passed. But I think, like Angela said, the military argument, I think the will is there. I think that certainly want to certainly want to take into consideration the chancellor's positions on that. But it has been, I think, for me, and I'm speaking in my role, that's been the position that has paused, kept it from fully passing in the legislature.
Here are the
Which
issues.
credit to the chancellors, I guess, but
Well, I haven't heard from the chancellors who were opposed to it. And I'm glad to hear that Bryce is saying that some chancellors were opposed to it, because definitely if some are, then we want to make sure that, you know, that consideration is taken into account. I will say too, that I think Professor Bell, and I raised this at the October meeting, raised a good point, that if we decide to do it, or if that's the recommendation, there probably could be some exceptions that are made, because the child support is one, the tuition is another one. Because if you have a child that is in college then, and Winetta Tatum and I, we've been discussing this for several years, from Jud A to me being now on Jud B, the tuition is huge. And so that's another consideration. So I think Professor Bell has a good point, is that if that's going to be a recommendation that the task force makes, then maybe there be some exceptions that are put into place.
But from what I understand now, a chancellor can order support for college up to the age of 21. If the child has the aptitude for it, the child has a good relationship with the payor parent, and it wouldn't substantially interfere with the payor's standard of living. And that we are to lean on granting child support rather than not granting child support. So the power to order support for college is already there. We just need to make it clear that it necessarily wouldn't cut off at age 21, but rather 4 years.
Well, I think that's the point, Judge Odom, is that we need to make that clear, because we have a lot of, unfortunately, this does happen, where you have a lot of children who are students who are in, whether they're at Ole Miss, Jackson State, any Southwest down there in Summit. Once they reach a certain age, they're having issues because of the parents getting that support. So we need to make sure that that's clear.
Isn't there a fundamental shift, though, that we're talking about in possible exceptions? Because in essence, child support is paid to the custodial parent. And we're talking about the exceptions where child support would be paid directly to the child. And maybe that's the correct thing to do, but it seems to me that that is somewhat of a fundamental shift in child support that would have to be addressed.
Yeah, my comment was going to be, is tuition child support? And if we set it as tuition, is it under the purview of DHS to handle those cases when someone's not paying?
How do other states classify tuition that are, I mean, there's 47 other states. Surely they've solved that issue.
Exactly.
Well, they probably have, well, I don't know. I don't know the answer.
I don't know how it's classified. I did notice that some of the states that cut off support at 18 make an exception for college support, but I'll be real honest, this was the last of the handouts I got to, and I didn't read it as thoroughly as I read the others. But I think there are some examples in here of how to do that.
I don't want to speak for Justice Griffiths, but I've recently researched the issue of college support, and the case is no child is entitled to have their tuition paid for by their parent. You're not entitled to that as a kid. You earn it through having a good relationship with your parents, having the aptitude for it, and not disrupting the normal standard of living of the payor. So it's taken a little bit of a hardline approach to, you're not entitled to it. 18-year-old, you pay for it yourself. And I think a lot of people may still hold that position. But in those situations where the child does have the aptitude and does have a great relationship, and the parents can't afford it, I imagine that's the way the other states handle it. If it's a possibility, then.
Yeah, I wish Mr. Chin would chime in on this, because I think that
I
this is
agree.
something more of a problem in high dollar divorces,
It is.
where you have a custodial spouse receiving a very large award of child support that continues until 21. And the question becomes, from that award, is college paid for? Is that expected to maintain the custodial home? And that seems to me to be the area where pushback's going to come on the change of majority, and will have an impact. Because like I said, it seems to me that moving the age of majority to 19 and creating the exception, there is a fundamental shift, because you're going to say in all divorces, child support to the custodial parent will end at 19 no matter what. And from that date forward, the support, if it meets one of the exceptions, would be paid to the child, would be paid directly to the school, would be paid in some other fashion that's different than how we've dealt with child support previously.
I'm
Mark,
looking
I-
back at the research that was actually presented by MJC to see if it addressed college for those states that have 18 or 19.
Judge, one of the things I want to say, and this may not make a ton of sense, but I don't know what we're talking about. I love saying that in public to a bunch of lawyers and people that are very high level people. But, when we were looking at perhaps creating or suggesting the legislature look at a 14th ground, it was to cure what we have seen as a thing that may hurt Mississippians. When we looked at whether PERS needs to be divisible, it was a way to deal more equitably when two people are divorced, only one of them is vested in PERS. So I think the thing I'm struggling to do with the age of majority issue is, first of all, I don't think I have a dog in the hunt. But if I don't have a clear through line of, do we have a ill that we need to cure, or if there's a problem that we need to fix, I think I'm hesitant right now. I just wanted to voice that. With the others, there was really interesting material to read, and I felt like I learned a lot and felt like we were accomplishing something. With this, I'm not necessarily sure what it's to help. Does that make sense?
Well, what I hear is the legislature is leaning heavily on doing it anyway. Why even bring it up? Let them handle it and not put ourselves out there with a recommendation for those reasons that you raised. I'm cool with that. And if it's going to be a done deal anyway.
I don't want to muddy the waters at all, but I'd want to make sure, one concern that I have, and I've done a little bit of research and don't have an answer, but I wouldn't want there to be any unintended consequences that children who are in CPS, that they age out of the system at 18 as opposed to 21. And I think that there might be a way to do that, but that's the one concern that I have with lowering it. So right now,
If the age of majority were lowered to say 19, what do you mean you don't want them to leave until 21?
like children in child protective services, that they would lose out on any state services at a younger age.
I understand. Yeah, I got you.
So Angela and I just talked, I mean, and I think our position is if the task force, for the reasons you're talking about, don't want to make a recommendation, that because to your point, that there is this will in the legislature to see this done, it's not necessary, I guess, if you're going to put it that way.
Yeah.
But I think this discussion has certainly been helpful. And I think the research certainly been helpful for me. But in terms of if the committee's not, or task force is not comfortable with a recommendation, we're fine with that, obviously, too.
We don't have to make a recommendation on anything.
That's true.
So as long as y'all know that they're, if the intent is, well, they can serve in the military at age 18, they ought to be able to be an adult at age 18. That's great. As long as y'all know that that may affect child support, and y'all just address that in.
I don't want I guess at the risk of reiterating myself, I think that when that is the will of, or the position of the legislature, but then when that starts going through, you get chancellors who call people for the reasons that we're talking about, and then it puts a pause on it. Maybe this can be discussed at some point. And now that we've had this task force discuss it, it's, everybody knows where things are. So
Justice Griffiths, Judge McCarty, myself, Judge Joe Schlegel will be addressing the Chancery judges within the week.
Okay.
In fact, a week from today, as a matter of fact, we will make sure that issue is bantered around with the Chancery judges. But here's what I hear from the Chancery judges. They are vehement about the no fault issue.
Okay.
Not about emancipation. But there may be some out there, and we'll flesh them out.
But I would like to say too, if the chancellors have any consternation about the emancipation issue, like I stated a few minutes ago, we definitely want to hear that and take that into consideration as well.
The Fall Judicial Conference is next week at the Jackson Hilton. I believe we're set to discuss this in a panel on Friday morning.
Oh, good.
Feel free to, if y'all want to stop by and hear what the chancellors have to say from their own mouths, please do. I'll make sure that y'all get the time and agenda if y'all or anybody else on Jed A wants to stop by and take part in the discussion. We'd love to have them.
Can we table the age of emancipation until after the the judges conference and then maybe address it in the next meeting?
Sure. I think that's a great motion made by Mr. Blackledge to table until after the judicial conference. We can raise it at our November meeting. A second on that from anyone?
Second.
A second from Senator Wiggins. All in favor, say aye. Any opposed? Say nay. Hearing none. Great. We're getting work done. I like it. Okay. The next item on the agenda is the support for adult disabled child. I really want to make sure that Senator Nelson, is it from DeSoto County?
Parker.
Parker knows that we are working on this since that was specifically mentioned in Senate Bill 2621. There was also research provided through the MJC concerning this issue as to how other states address it. So I'd love to open the floor for any discussion on that issue. If I'm not mistaken, Senator Parker's bill, which I think has all been provided to everybody and is in your materials, would allow for the payment or would allow for chancery courts to order child support payments for adult disabled children. Which is the state of the law is now. There's no obligation whatsoever for a parent to pay child support or support a child beyond the age of emancipation, unless, as in the Ravenstein case, it is previously agreed upon by the parties through an agreement.
That's great.
So,
I-
yes,
Well, at this stage, I'll make a motion to a recommendation that bill or that the task force adopt that legislation, that change.
okay. I don't know how many we have.
And if I may, because I remember from the last meeting that we did talk about that, and it was the case, and my recollection is that it seemed like Mississippi was one of the few states that wasn't doing that, or certainly prohibited. So, and, that's my motion.
Man, I feel like we've got a gem with Professor Bell being here in person. Do you have a stance one way or the other?
So I did read all of these. It's, I'm sorry, my brain was going in one direction, my mouth in the other. I would certainly favor us doing this. I made a list of 5 or 6 things that I saw in these other statutes that I would love to see us consider as part of that. So all of these seem to say that the disability has to exist prior to majority. So that's one. One of the states will allow chancellors to go back and award support for children who were disabled prior to majority 5 years ago. So in other words, it's not just prospective. It could apply to disabled adults who were disabled prior to their majority. Did that make sense? You look.
Yeah, I mean, that's what Parker's bill discusses. It has to be
Okay.
a disability in existence at the time of emancipation.
Right, but it's not for people who are just being emancipated now.
It would give chancellors the ability to go.
Like if there's a
back.
25-year-old who has been disabled, I'm not sure that's a good idea or not, but that's what one state did.
Okay.
In other states, it just seems to be prospective. The other thing that seems really critical to me is that there are so many definitions of disability. And I think there are some people who are disabled who can work. So I like the ones that say that it depends on a chancellor's finding that there is a severe disability that prevents the person from supporting themselves, so that it's the chancellor making that decision.
Is that in Parker's bill?
So that's what I was looking at.
It was.
It created a presumption and I'll just quote it here, the presumption of emancipation may be overcome by evidence that an adult child is incapable of self-support by reason of a physical or mental disability if it existed during the adult child's minority.
I don't have a copy of that.
That's lines 148 to 152.
Senator, do you have a couple extra copies of that? I'm not sure if I have one, and I want to make sure Dean Bell has one.
I've got it right here if you.
Yeah, I
wanna
don't
make
want to be
copies.
repeating things that are already in there. I'd love to see that if you don't.
Yeah, you can,
We can
we
share
could
one.
make a copy. It was in the packet that we gave out the first day.
Sorry.
Oh, it's under the.
As a chancellor, I look at that language that you just quoted from and I'm thinking, whoo, look at all that discretion that a chancellor has
Uh,
that must be found to be an abuse in order to overcome.
See, the legislature gives you a lot to work with.
Oh, yeah.
What section?
That's lines 148.
Right.
Prevents the child from living independently
It's in the.
unless the
It's in
child is a
his
long-term patient.
Oh, okay,
That's not-
great.
That's the 2355. That's not the bill. We're making copies of, yeah,
It's in that first packet.
we're making copies.
I think this is on page.
Yeah, I'm looking at Senate Bill 2220, subsections D and E, the underlined language that would be added to the bill. It's fairly simple.
And to your point, there is a lot of discretion.
Yeah.
I mean, because it creates a presumption that, that a rebuttable presumption,
The Supreme Court
Well,
may be.
we've always-
which means that
Deciding
y'all are the
that-
chancellors, but which means that if somebody, that it's automatic unless somebody comes in and wants to say, put on evidence that they shouldn't do it. I wonder, I mean, are parents really going to do that?
They absolutely will. Yeah.
That issue has been litigated in my court
Okay.
numerous times.
I had a really bad one time, and there's still a lot of developing treatments for kids who are, one of the more preferred terms now, I think, is neuroatypical. We were saying autistic when I was practicing law and different things like that. And the parents were really fighting over the course of treatment, some of which was a little bit more mainstream and some of which included like the hyperbaric oxygen chambers even. And of course, that was much, much more expensive. And so it was a huge mess, honestly.
Any other discussion on this? I could see that there being a number of appellate court cases to make a determination on what is a disability, what is incapable of self-support mean. I'm sure that Senator Parker has put a lot of thought and effort into what language would be added to this legislation to avoid as many problems as possible or ambiguity that could possibly come up as a result of it, because I do imagine it may be litigated. Because you're talking about someone paying money indefinitely, rather than at a cutoff that would be 21.
Right. And that's, and on that issue, and I'm speaking as having had discussions during last session with Senator Parker, I think that was some of that, and that there's no cutoff. That the way it's written, it could be until they're 40 years old or something like that. So is that what we want? Now, that stuff can be hashed out during the committee process of the legislature. But that's a good point.
Okay. Anybody else? I know Mr. Chen was very much in favor of this when it was brought up at our first meeting.
Yes, can you hear me?
Yeah.
Okay, I was muted before. I was trying to speak on this child support issue, but I'll send you an email. I'm very in favor of doing something to expand support past majority for disabled people. It's a very significant issue.
Okay, so where we left it prior to getting into discussion was, if I'm not mistaken, Senator Wiggins had made a motion to accept or to, made a motion to have a recommendation to support Senate Bill 2220.
That's correct.
Is there a second on that? Do I get a second? I just forgot about it.
No.
Do I hear a second?
Second,
Oh, it was Mr. McCauley, I think, beat you to it. All right, so
I need to look at that, but I think we get the gist.
you want to say anything else, Professor Bell?
Judge, I think I'm unfortunately going to drag her into it. Is there anything else? I mean, we've seen, because Dean Bell looked at some of these other states, I really like Senator Parker's language. And I love how broad it is, honestly. Is there anything else we could do that might arguably improve it, looking at your research?
This looks great. I
Dean?
just had not read this before. The only thing is that if we want to add factors, like one factor that some states include is to be sure to consider the resources and benefits available to the child, so that the court's not ordering parents to pay when there are federal or state benefits that would cover those
Might be
expenses.
Social Security
That-
benefits.
That would be the biggest one I would.
Those factors are either going to come from the appellate courts or from the legislators.
Or it could just be a sentence that says the court should consider the benefits available to the child prior to, or something like that, just to make it clear that it's not in addition to.
We in the legislature certainly like if it comes from us. So, you know,
I could just see that there's going to be the McCarty factors 6 years from now that the courts are going to have to consider prior to ordering. There's just another list of factors for us to discuss.
I just want to use her as much as we can while she's with us.
I apologize, Professor Bell. I did not give you time to read.
what
Oh,
can be.
no, that's,
I-
this is, I mean, this covers everything except for that one thing that I was going to suggest.
I don't mind taking a break because we've been going an hour before we.
I read it.
Okay. So the motion's been made. There's been a second. All in favor of the motion, which was to recommend passage of 2220. Say aye.
Aye.
Any opposed? There you go. All right. Man, that's easy.
We got one left.
Oh. Hey, let's take a brief recess. We've been going an hour. Let's take a brief recess before we get back on child support payments for incarcerated individuals.
That's literally what section eight is.
And so the duty of child support terminates upon emancipation of the child. Language is presumption is that they're exclusive unless, yeah, that's the way. But they want it to be out. Well, yes. I was raised about you need to.
Basically, you're saying the
They want-
emancipation doesn't apply.
They want a presumption of disability, so they basically want.
Okay, yeah, I think that's how.
We need to clarify that. So then I'm just gonna-
Okay. Yeah, it's probably just, there's a presumption of disability. Yeah. That's right. Hey, Reed. Is this exciting? Love the what? Right.
Yeah, I found some language here.
I think, yeah, we have this, we can make, I'm happy to give you, it's a good, right here.
That's in New Jersey.
Yeah, it gives the good language right there. It's a
So
good
the child
piece of,
eligible for public benefits and services for people with disabilities.
and it's actually, this is written in like two, so we, the legislature, will have to decide, but it's either irretrievably broken or complete incompatibility. So, you know, what that, that's what Ethan was saying, to us choose that. So it's gonna be one of those two, but the recommendation is meant to add a 14th ground that, like this says, upon application of either party. See, right now, under the law, it has to be both, or you find it in a trial.
Or Magnolia, whichever it is. Yeah.
Dress, we're headed to New Orleans, so I was trying to dress for New Orleans weather in here. We have two of our children, and two of our
Dowdy-
grandchildren are there. And so
Daddy's still with us.
so we're there constantly.
Still practicing? His daughter's still down there? Y'all ready to get back started? Okay, so the last matter that the court has on its agenda is the issue of abating statutorily child support payments for incarcerated individuals. Last meeting, we had a lively discussion about this issue, and we heard from Mr. McCauley about the Department of Human Services position on it. I think now that we have Professor Bell, there may be, is there anything else that you wanted to add to that? The consensus was statutorily abating it upon incarceration to prevent the buildup of a debt that cannot be satisfied.
I think this is a great bill.
And you provided the bill, Mr. McCauley, I think, that y'all had proposed.
Yes, we'd submitted this last year.
Okay. What happened last year? If y'all remember, I'll ask the legislators. Ah. Got it. Okay.
Can I ask? Well, can I ask a question? Because I'm not sure I fully understand it, but does this bill, I mean, if it abates child support while somebody is incarcerated, does it prevent the execution upon other assets for the collection of a judgment if the incarcerated person has other assets that are available? And does it allow for it not to be abated if let's say a person is incarcerated, but does have these other assets to pay?
It does allow that. So essentially, there's two exceptions. It says child support shall be suspended until either of the following conditions exist. The person owing support has the means to pay support.
Where are you?
2A.
Okay.
And then section B is if the person's incarcerated for domestic violence, child abuse, or criminal non-payment of child support. So it does allow, I think this is a concern among chancellors that you might want to get a pulse at the conference next week. I think a lot of them might not be in favor of this, that it takes away some of their discretion. They want to, that's what I've heard, is that they have some concerns about suspending it by operation of law. But
Well, we could certainly take the pulse. I don't know. I've heard from many chancellors that would be opposed to it. I mean, we understand the realities of, we're just setting people up for failure unrealistically and unreasonably. And you can always execute, like Justice Griffith says, if there are other assets out there, nothing is preventing you from actually.
And I think in practice, the way that this would work is we would give both parties notice. And I think probably the CP would, the custodial parent would notify us if they have assets or would still have the ability to pay while incarcerated. And at that point, we can make a decision to.
So how would it work in the bill? Would it just automatically statutorily abate, but the payee would have the option of filing a petition to not abate it if they believe that there are assets or they have other income?
I think that the way that it would work is if we thought that there were assets, we might file something with the court to make that determination of whether or not to cut it off.
Well, as I see it, in a non-DHS case, it would be one which would be considered in a petition or an enforcement action contempt action to enforce payment of child support, the incarceration would now be a reason not to pay under this, and would be an excuse for not having paid.
Burden would be on the payee,
We certainly,
not
will.
the free individual.
I mean, the only way it would come to court is if the payee was trying to enforce payment.
Yep. I think that's reasonable.
I have a question for Professor Bell.
Don't
You
we
said
all?
you think this is a great bill or great proposal. Why?
So I did a project with a prison over the last 3 or 4 years and talking with the men about legal issues, and family law was what they most wanted to talk about. And child support was what they most wanted to talk about. And what they said is they get out, they don't know how to get the child support abated, even though I know they get instructions, but they don't know how to do it. They're anticipating getting out. They're going to owe a huge amount of arrears that can never be forgiven. They can't be bankrupt. And those arrears then follow them around. And the studies that I've seen is that it drives people into the underground economy. And it in some cases keeps them away from their children because they don't want to go see their children and get served. And that when they really don't have any resources, it's not helping anybody. And it's really hurting people on reentry and hurting their families. So that's.
I fully support it. Playing, I guess, anticipating questions. What about it's their kids and they should be, what do they say about honoring their obligations as a parent to the child? And
The folks I talked to, now obviously this was a very self-selected group. They had signed up for this. They wanted to learn about the law. They're thinking about what they're going to do when they get out. They want to get a job and want to support their children, but they don't have any resources. It certainly shouldn't apply when they have resources or they have some source of income or they have assets or something that can be used. Their point is just on what we get paid in here, which I think is below minimum wage. There's no way we can fulfill our obligations under the child support.
And I think we mentioned this last time, Angela and I did, but that's in line with the criminal justice reform that has been done within the
Very much so.
legislature, because what we're trying, they've been set up to fail, or just by the nature of it, they're set up to fail. And we're trying to make them productive members of society. And what I'm hearing you say is it's kind of the debtors stuff that's been going on. And we want them to have relationships with their family, children. We want them to work. And so I think that tracks along the same lines that we've been doing.
I think it does. That was part of the discussion that we had in Judd A, is that it was a part of the criminal justice reform piece and reentry and
Okay.
yes. And so it would track along those same lines. And I remember when we did bring it up on the House floor, I mean, there was very little, if any, debate about it. And the same in committee as well.
Okay.
I've seen a number of cases where, certainly one of the ways to enforce child support is to hold someone in contempt and have them incarcerated. And the problem with that is it just keeps building. They keep getting deeper and deeper and deeper. And so when they get out, if they've got, they couldn't pay $1,000, so they certainly can't pay $5,000. And so instead of acknowledging their inability to pay, because that's certainly one of the factors. In jail, you have an inability to pay, although sometimes it's viewed that you have an inability to pay because you chose to not pay or you chose to commit a criminal act, that it also, when they get out, they have no ability to pay and no incentive to try to want to do what's right for their children. And they don't. And it seems like it's a cycle that, they're going to incarcerate. Can they find any money? And it just seems that this is the real reality of it, that even though a custodial parent has an obligation to pay. There are circumstances in life where they don't have the ability to pay. And it only makes sense to say, while you're incarcerated, that's, we're not going to keep adding to the amount that you owe.
And I would just add, if you get questions, maybe I didn't explain it very well at the last hearing, but this is a federal requirement that states can't consider incarceration as voluntary unemployment. And so it could affect the agency's funding. And then the last thing I would say is in our last appropriations bill, there was a requirement that we submit a yearly report on how we're addressing arrears. And this is one of the ways we're tackling arrears. One way we could tackle arrears by stopping them from accruing.
Okay.
Anyone want to make a motion regarding this issue?
I'd make a motion that we support the bill that Michael provided.
Yeah, make a recommendation. Thank you, Professor Bell, seconded by Justice Griffiths. Any further discussion, Mr. McCauley?
Are we going to include the bill that we submitted also included federal requirements about considering basic subsistence needs and imputation? It's on page 4. I don't think it's anything controversial at all, but again, it's a federal requirement that we included in our next quad review. So number 4, is it just that the court shall take into account basic subsistence needs of the obligated parent who has an inability to pay. And then when you impute income, in lieu of fact finding and just setting a low amount, you're really looking at the particular facts of the NCP's ability to pay. So looking at his resident, where he lives, his job skills, education level, and things like that.
Motion remain the same if it's includes that as well, Professor?
Yes.
Justice Griffiths. Okay. So any further discussion from anyone else? All in favor of recommending the recommendation of MDHS on the issue of child support for incarcerated individuals, say aye.
Aye.
Any opposed? Excellent. Okay. Okay, so that comes to the end of my agenda. I'd be more than happy to continue the meeting to make sure that Senator Wiggins doesn't have an opportunity to support the LSU Tigers at Oxford.
Okay.
I don't know. I'm just messing with him. I'm trying to get him. You're not going to get voted in after what I just said.
He impugned your character. He impugned your character. All right.
You're supporting the Rebels this weekend, correct? Yeah. Of course.
Mr. Chairman, I'd just like to say this. I'd like to see what we can do to, I think we've got one more meeting scheduled. Is that right? Are we through with them?
Well, I think I had scheduled one for December as well, but I think Justice Griffiths, you brought up the fact that we may need to have something written and submitted to the legislature prior to
Well,
December.
My memory was that there was a date that we were supposed to have our
Oh, yeah.
guideline or our recommendations submitted. But I think it's a good idea that right now that our focus to be to get the immediate priorities that, Chairman Wiggins and Cochran believe that we can actually have filed and have an impact on during this session. And that we also recognize and see if there are other issues that we can address and kind of continue the task force, because, what we were tasked to do was pretty expansive. And I think we focused on some priorities, but I think there are a lot of other things that we can accomplish. And I would even say that, from my standpoint, a discussion of court procedures would be helpful, whether or not there needs to be procedural changes that the task force suggests, which would be a suggestion to the Supreme Court and maybe even the Conference of Chancery Judges, and case decisions. There have been some case decisions. We have law now by case decisions. Is it correct? Is it not correct? Is it something that needs to be changed? by some statutory additions or changes in the future. And I just don't see that's anything that we could have done for this session, but I do believe it is something that by the session in 2023, we could have really a more comprehensive review and final bill that deals with these other issues that are equally as important, simply not as pressing. And that I think it would be helpful if we at least ferreted out some of those issues, some of which we may reject, some of which we may want to proceed further with. And I would like to know and give Professor Bell and Professor Kennedy some more leeway from an academic standpoint to make some presentations to us and research some things in academia that would be better helpful, because I think seeing what other states are doing in domestic relations will go a long way with your efforts in the judiciary committees to make sure our domestic relations laws and procedures are the best for our people of Mississippi. And so I don't know how to extend it, but I do think that anything we do right now needs to be devoted to getting the proposal that, or the report that's necessary for this session. And also, can we set meetings for, upcoming months and continue this? I'd hate to stop for 4 months and do nothing. I'd much prefer to continue on maybe in a monthly manner. But with the view that right now, what's most important is the recommendations that we're submitting to the legislature this session.
Can we do it this way? Can we have somebody make a motion and vote on it? The recommendation being to continue the task force to address, I mean, it's implicit in the issue of child support.
So moved.
Thank you. Any seconds? Can I second? I'll take that as a second from Professor Bell. Go ahead.
I'm sorry, yes, if the task force recommends it, make that recommendation, if it's adopted.
Yeah.
then that would be part of the recommendation. And then, I guess procedurally, we would just go do the same thing. Like here,
Do you foresee that being an issue? Great.
not particularly not if this task force says, hey, we got more to do.
I think we definitely have more to do on the child support issue. That's for, okay. It's been motioned and seconded. All in favor, say aye. Any opposed, say nay. Great. That'll be another recommendation.
December 1st in the legislation was when to have the recommendation. That actually goes back to what we mentioned earlier, so the chair folks can get this prepared.
Okay.
It says, with the recommendation, we'll change to the. I will note that it says the task force shall develop finding recommendation to the legislature and propose rule changes to the list.
So is the idea that I don't know if this is duties of our secretary, but I mean, we need to come up with a report that, a white paper that says this. Will y'all write that? Okay.
The council will do that.
Okay.
Oh,
And we'll do that and say, here's the recommendations. And the ones we've done before, here's the 4 recommendations.
Just want to make sure I'm not writing a report.
okay. So we have another meeting set in November. We may make other recommendations at that meeting in November. Is that going to give your expert writers enough time to do that and have us vote on it, because we have to sign it, if I'm not mistaken?
Here's what maybe I would make.
Yeah, you.
Is that prior to that meeting, and I think y'all can go ahead and prepare the recommendation letter or whatever, circulate it, and it will appear at that meeting and sign off on it.
Get everything except for her.
I think it's pretty clear that the PERS issue is not going to be able to be finalized as a recommendation between now and the next legislative session.
But that's certainly an issue.
You're right.
Next year or certainly after we get reconstituted.
Okay, so I know that Justice Griffiths wants to discuss some procedural or rules issues.
Well,
You
I
may
do.
have some information to,
Yeah. Well, I do, but that doesn't have to be today. I want to
No.
make sure that there are some procedural issues. You know, I certainly am an advocate for changes in Rule 81 to make it a little bit easier procedurally. There are some proposals that are currently pending before the Supreme Court for rules changes on those things. The Civil Rules Advisory Committee and the Conference of Chancery Judges have considered some of those, but I think the way I read the task force's charge, it is important for the legislators and other members of this to have an opportunity to discuss and propose procedural rule changes to the Supreme Court. And I want to make sure that happens, but I don't want it to interfere with the recommendations that we're making this session, because time is not really of the essence in those changes. But I did want to, at some point, whether it's next meeting or maybe next year, that we start ferreting out some of the issues that relate to rules changes that would have to come from the Supreme Court.
I was just going to mention, you may have some information that you want to circulate to the members prior to our next meeting.
Possible.
So be on the lookout for that. That'll be an issue that we discuss on the agenda for next meeting. Motion to adjourn? Do we
May I
have
ask
anybody?
May I ask one thing before we go?
Yes, sir.
Would someone who's going to the Chancery Judges Conference maybe make some notes and email them to us before the next meeting on their idea about emancipation?
Absolutely. I'll do that. I'll do that. I'll give y'all a full report on what we discussed as it relates to the issues before the task force. Thank you, Mr. Blackledge. All right, motion to adjourn. Did I hear that?
Sure.
All right, good. Second, all in favor, say aye. Any opposed, say nay. Excellent.
Hey, I'll put the minutes unless you need them. I'll just stand on the. I'll just be the document.